He had owned firearms his entire adult life, renewed his license on time every 5 years without issue, and then one single piece of paperwork, a protection order he hadn't even fully processed yet, triggered something he never saw coming. His license was automatically revoked. Not after a hearing, not after a conviction, automatically, the moment that order was issued, and he had 24 hours to hand his firearms over to a peace officer. That is not a hypothetical. That is the actual law in Canada right now, and it is one of several major changes inside Bill C-21 that most licensed gun owners still do not fully understand, even though it directly controls whether they keep their license or lose it. Bill C-21 received royal assent in December 2023, and most of its measures are already fully enforced. This is not a proposal anymore. This is the law you are operating under today, whether you have read it or not. Here is exactly what it actually changes for your license specifically, broken down piece by piece. The first major change is the national handgun freeze, which is now codified directly into law. With limited exceptions, the sale, purchase, transfer, and import of handguns by individuals is restricted. If you already legally owned a handgun before the freeze took effect, this does not strip your existing license or your existing firearm away from you. What it does mean is that the pathway for acquiring new handguns has been fundamentally narrowed, and very few new exceptions exist outside of specific professional or protective circumstances. The second change, and this is the one most gun owners genuinely do not see coming, involves protection orders. Under the amended Firearms Act, if you become subject to a protection order, your firearms license is automatically revoked. Not reviewed, not flagged for a hearing first, automatically revoked the moment that order is in place. And once that happens, you are legally required to deliver every firearm you possess to a peace officer within 24 hours or within an extended period set by your chief firearms officer if circumstances make that immediate deadline genuinely impossible, such as being out of the country at the time. This applies regardless of whether you have ever been charged with anything related to firearms. The protection order itself is the trigger. The third change is what's commonly called Yellow Flag Authority, which came into force in March 2025. This gives your provincial chief firearms officer the power to suspend your license immediately if they have reasonable grounds to suspect you are no longer eligible to hold it. This is a suspension, not a full revocation hearing first. It is designed to act quickly in situations where a concern has been raised, and it means your license status can change before you've had a chance to respond to whatever triggered the suspicion in the first place. The fourth change is red flag law, which works differently and involves the courts directly rather than your CFO. Under this provision, essentially any person can apply to a court to have firearms temporarily removed from someone for up to 30 days if there is a genuine public safety risk to that person or to others. This is a judicial process, meaning a judge is involved and reasonable grounds have to be shown, but the application itself can come from a family member, a concerned individual, or law enforcement. It exists specifically to fill the gap in situations that don't rise to a full criminal charge, but still represent a real, identifiable risk. The fifth change affects anyone with a domestic violence history. As of April 2025, a firearms license will not be issued to anyone convicted of an offense involving threatened or actual violence against an intimate partner or family member. This is now a mandatory refusal, not a discretionary one. If you fall into this category, there is no case-by-case argument to be made at the application stage. The conviction itself is the disqualifying factor. The sixth change is something most license holders never think about until it directly affects them: information sharing. Bill C-21 allows certain firearms license information to be shared with law enforcement agencies across the country, specifically to support investigations into things like trafficking and smuggling. This means your license status is more visible across jurisdictions than it used to be, which matters if you are ever involved in an investigation that has nothing directly to do with you personally, but touches a firearm that was once registered in your name. Here is what ties all of this together and why it matters more than any single provision on its own. Before these changes, losing your license in Canada generally required a clear process: an application for revocation, a notice, an opportunity to respond, and a referral to a provincial court if you disputed it. What Bill C-21 has done is create several new pathways where your license status can change quickly, sometimes automatically, sometimes based on suspicion rather than conviction, specifically in situations connected to domestic violence, protection orders, and public safety risk. The legal logic behind this is straightforward. Lawmakers wanted faster intervention in situations where waiting for a full process could put someone in danger. Whether you think that trade-off is the right one or not, it is now the actual legal framework every license holder in Canada is operating under. So what should you actually do with this information? If you are ever served with a protection order, understand that your license is affected immediately and automatically, not eventually. If your personal circumstances change in any way that could be relevant to a public safety concern, understand that yellow flag and red flag mechanisms now exist specifically for situations like that, and they move faster than the old system did. And if you are unsure exactly where your own situation stands under any of these provisions, that uncertainty is worth resolving directly with your provincial chief firearms officer or a lawyer who specializes in firearms law before a situation forces the question for you. Bill C-21 didn't just add new rules around acquiring firearms. It fundamentally changed how quickly and under what circumstances your existing license can be suspended or revoked. Most of those changes are already fully enforced today. Knowing exactly where you stand under them is not optional anymore. It's the baseline for understanding your own legal position as a licensed firearms owner in Canada right now.